Welcome to a program on fair use strategies and decision making in libraries and universities. We've had many programs on fair use, but this one we hope will be a little bit different. And to welcome us, though, to the university and to the libraries especially, my colleague and supervisor, boss, and good friend, Jim Neal.
No one supervises Kenny Cruz, I can assure you. Yes, as you know, when universities sponsor these types of programs, they will often trot over from one of the administrative buildings the appropriate and proverbial administrator to welcome everyone to campus. And so in many ways, I serve that role today. I wanted to echo Kenny's welcome. We're very thankful that there is so much powerful interest in this topic, and we are very pleased to be collaborating through the Columbia University Libraries and the Association of Research Libraries to open up this conversation about this new ARL initiative among the professional community here in New York. But I would add quickly that this is not your typical and proverbial administrator who has stepped forward. I have worked on issues of copyright as a layperson over the last 20 years, working in Washington, working in Geneva, and working in various forums to advocate and educate around the issues as they impinge on the work of libraries in service to their users. I argue that we represent the public interest in these debates, and we need to have a real strong sense of responsibility. I'm very pleased by the audience that has shown up. This, I often say when I give talks on copyright, is one of those MIGO topics. My eyes glaze over. But it's clear that the library community at large has grown in their understanding and awareness of this issue, knowing that we have a fundamental educational and advocacy role in this area. And I think we'll all benefit and learn through our conversation today. I have had basically three messages on copyright that I have been voicing over the last 2 decades. And I wanted to just reaffirm those in the hopes that they might influence some of our debate today. First, and this was a product of a talk I gave last year at ACRL in Philadelphia, fair use is not civil disobedience. We in the library community have within our copyright law a provision which is so fundamental and so powerful and so underutilized and understood. We have to employ it much more aggressively, particularly when other aspects of our copyright laws run so far behind the digital and network reality world in which we live in libraries. My second point is based on an article I published in the early part of the last decade for American Libraries. The title of the article was "Copyright is Dead, Long Live Copyright." And the first sentence in that article, for which I am forever embarrassed, went something like this. The American library community is confronted by a copyright access of evil. So you have a sense of when I wrote it. But among my litany in that access of evil was user guidelines. The notion that we would come to the table and negotiate with the content community and agree on a quantitative basis to limit our work to certain levels of activity when that's not necessary or required in the law, but we sort of kowtowed to that sense of expectation and requirement to provide the assurances and confidence within the library that we were not breaking the law. I have argued against that, and I'd be interested as we talk about the new ARL study how that fits into that access of evil. My third and final point is that ambiguity is our friend. And the degree to which we're able and willing to live in that grayness and to make interpretations of copyright and fair use on a case-by-case basis in the context of our institutional culture, our personal sense of risk, then I think we're better serving our users who rely on us in such a powerful way for access to the information they need to do their work. So those are my sort of three messages that I hope will be helpful. I want to thank ARL for giving us the opportunity to participate in this discussion and this debate. I think we're the New York event, and you have shown up. Thank you. I also want to thank Kenny and Pat for their extraordinary efforts and work and accomplishments in pulling this together. When Brandon wrote to me, I said, yes. And then I said, Kenny, go for it. And here you are, and I appreciate very much that you have shown up and that you will engage with us and with each other in a great conversation around where fair use is taking us. Thank you very much.
Thank you, Jim. And did I fail to introduce myself? My name is Kenny Cruz, and I direct the Copyright Advisory Office here at Columbia University, based in the libraries. And I want to add some thanks to our colleagues from around the university who are here, especially from the Scholarly Communication Program and CEDARS, the Center for Digital Research and Scholarship. Some of you are here, some of you are here. Layla is doing a live feed, tweeting right now. And so really a great big thanks to all of you and the folks preparing the videotape as well. But especially thanks to all of you for taking the time to come here. We hope that there will be plenty of time for questions. How many of you have a question about fair use already? All right, we'll be busy. But I will be fielding the questions. There are also notepads, and I want to very recklessly offer that please, if you don't get a chance to ask your question, I need to not promise that I will answer it, but if you do jot down questions, I'll do my best to sort through them and paraphrase some of them and include them on the website that we host on copyright here at Columbia. But I'll be fielding questions with the microphone as we proceed. Well, I am licensed to practice copyright and practice fair use. And that does, I think, give me somewhat of a different perspective. And I say that only to mean that there are many different perspectives probably present in the room. But as we think about decisions about fair use, among the first decision is which path are we really going to take? Are we working with a fair use question? Or is it something that is associated with Creative Commons? Or does our activity fit within another exception? And what's the role of permissions and ultimately risk analysis in questions of fair use? And I'm hoping, I certainly will be listening for pieces like that that help us think about not what is fair use. We'll all debate that endlessly. But rather to talk about how do I make a fair use decision? What are some of the steps that I can go through? And on the slide right now are some examples. One of those images up there is a Creative Commons image that I'm using in accordance with the CC license. One of the other images is a photograph that I took, but it's fair use embedded within fair use embedded within fair use of a book that was the subject of a fair use court decision. So we have dynamics of fair use and other relevant decision making going on in one simple screen. And so let me allow as much time for the panel and as much time for your questions as we possibly can. You all have a program. We'll do our best to stick with it to the minute. And so I'm happy to introduce Brandon Butler. We have a biographical sketch of him as well in the program. He's here from the Association of Research Libraries. He will be taking the lead on introducing us to the Best Practices project and document as an instrument for thinking about making decisions about fair use. Peter Yazzie was unable to join us here, but this morning, a late call on his part, a necessary call on his part. But Brandon, I know, has worked with these issues and has been a partner on every step of the way. So I know he'll handle it very ably. And Brandon, come on up, and I thank you very much. And we will move to your slides.
Thank you so much. Thank you, Kenny, for that introduction. Thank you all so much for coming. And I'm so sorry that Peter couldn't join us. Something came up at literally the last possible second. But I know that, and I know it's killing him not to be here because he was really looking forward to speaking to all of you. But I promise I can get the job done. I've been working on this fair use code issue.
Yeah,
oh, am I a little there? Well, hey.
Is that picking up a little better?
That's a little better.
And maybe we can raise this up.
There we go.
How's that for you?
How's that for you? All right, there we go. So I've been working on this code for 2 years now with Peter Jaszi and Pat Aufderheide, and I'm here to talk in part about our code, mostly 98% about our code, but I also will say a little bit about this Code of Best Practices approach in general. So here's an overview of what we're going to talk about, right? First, I'm going to describe some recent developments in fair use that sort of made this whole Codes of Best Practices thing possible. We couldn't have done this, in 1985, and maybe not even in 1995, but in 2005, the stars had sort of aligned. The second thing I'll talk about is what is the best practices approach, right? This whole event is about different strategies, and the best practices approach is one strategy to help you make sense of fair use and make fair use decisions. And we'll talk about libraries and fair use. Why is fair use something that, brings this many folks in the library and university community together? And then finally, and very quickly though, because I know we're not trying to get down in the weeds, I'll talk a little bit about what's in this particular code that we've developed, but just to give you a flavor, and I'm going to emphasize that you really hopefully will want to go and read the document for yourself and really dig into it, because it's too rich for me to describe in this time. So first, what is fair use? Fair use is a space for creativity, right? This is something, and here I'm definitely carrying Peter's flag. This is his meme, right? We're trying to introduce it into the world. So what does that mean? What is this little slogan, a space for creativity? Well, it has three faces. First, it's a space for creativity in the literal sense that the current generation of creators, whether they be scholars who are writing and standing on the shoulders of giants as they study a subject, or artists who are appropriating and commenting on their forebears, this current generation of creators could not do what they do without fair use. Copyright would operate as a kind of private censorship regime, right, because it allows the creator of copyright protected work to control all copying and distribution of the protected work, right? So if there were not some exception along the lines of fair use, you couldn't quote in your scholarship, right? You couldn't make reference to a character from a previous novel in your novel because that character could have a level of protection that would stop you. And so fair use is what makes the current generation of creators empowered to continue to build culture. In the second sense, it is a space for creativity for lawyers, right? Unlike certain other legal provisions, how much CO2 can I put in the air if I'm a factory, or how fast can I drive on the highway? There aren't numbers, right? The fair use statute is a 4-factor test, and those factors are flexible, and that is so intentional. They evolved over a century and a half before they were codified in the law. And when they were codified in the law as the 4 statutory factors, it's very clear that Congress actually didn't mean to sort of change anything or to stop the evolution of this flexible doctrine. They meant for things to keep on changing and growing, and for lawyers and judges to have the freedom to explore new ways of talking about using copyrighted work. And so it's a space for creativity for lawyers who represent clients like you guys. When you come to your lawyer and you say, this is something really powerful and interesting that I want to do, but I'm not sure what the copyright implications are. As Kenny said, there are many different exceptions available, right? You might be within Section 108, and that's great. You might be dealing with a document that's in the public domain or is licensed under Creative Commons. But if none of those things applies, fair use creates an option for your attorney to say, there are ways that we can talk about doing this legally despite there not being any specific exception that deals with your case. And then the third way that it's a space for creativity is that it's a space for creativity for judges, right? It was actually a doctrine created by judges. In the good old common law era, there was no exception to copyright for something as simple as quoting in scholarship. And so the first fair use decision had to do with a biographer of George Washington, whose biography quoted extensively from a previous biographer. And the question was, Is he quoting the way biographers do in a scholarly way that would be legitimate? Or is he just sort of ripping off the earlier one and taking all the best bits and putting out a cheap edition? And there was no way for the judge, there was no explicit provision in the copyright law at that time for the judge to say that to quote in this way was okay. But instead he sort of made up this common law doctrine of fair use. That, well, surely it would be absurd for copyright to operate in such a way that it prevented scholars from doing what they do. And so I'm not going to do it. And judges to this day have that option of equitably applying the 4 factors in the fair use test to let legitimate practices go forward despite a facial copyright challenge. So what's the specific good news that we've had? That's the good thing about fair use generally, and that stuff's all been true for a century and a half. But what happened in the last 2 decades to make codes of best practice and sort of to make it possible for, I think, communities to engage in fair use, to engage with fair use in a way that really wouldn't have been possible before? Well, the first is that judges have really come to love these balancing features in copyright. As copyright has gotten longer and stronger, judges aren't blind to that fact. That is, as copyright terms have gotten sort of essentially infinite, right? They get extended every 20 years for another 20 years. And as it has become literally, there's literally nothing required to obtain copyright. If I write a poem on a napkin and throw it in the garbage, and you find that napkin later, I can sue you for reprinting that napkin, right? So all I did was write my poem on a napkin. I didn't have to register it. I didn't have to put a Circle C on it. I didn't have to do anything. And now, right, 70 years after I'm dead, my daughter will still be able to sue you, at least for 1 more year, for using that thing. So copyright's gotten really, really long and really, really strong, and judges aren't blind to that fact. And in fact, there have been 2 Supreme Court cases that say that if it weren't for fair use and another doctrine, the idea-expression dichotomy in copyright, that copyright would be an abridgment of speech inconsistent with the First Amendment. Because again, copyright allows private censorship to a certain extent. And it is only the fundamental, it is only the availability of fair use as a defense that keeps, along with the other doctrine, that keeps copyright on the right side of the Constitution. These weren't great decisions in other respects, but they were really good decisions for fair use. And so we have judges saying fair use is a First Amendment right. It is an aspect of your free speech rights. It is the counterweight to this ongoing and growing copyright regime. And then thirdly, fair use judicial interpretation has shifted greatly since 1990. So until 1990, we had the 4 factors, right? And judges were just applying the 4 factors, and even judges weren't happy with how that was going. In fact, it was one judge, Pierre Laval, who's a really one of the most respected jurists of his generation, who, as an appeals court judge, had issued decisions that he knew sort of, I wrote the decision, I'm the judge, introspecting, I know. I don't know what I did when I made that decision. That is, he couldn't explain, why he had come out the way he did. He felt that the 4 factors, the way he applied the 4 factors, he didn't have a theory of what those factors were about. How do they interact? Which ones matter most? How do you decide where the scale lies? When does it tip against fair use or in favor of fair use? And so he wrote an article in the early 90s articulating a theory of fair use. What do the 4 factors really mean? What's going on here? And admitting some of my decisions didn't get it right. Some of the other decisions some other judges have done better than I have. And he sort of tried to pick out, how have judges gotten it right and wrong based on this theory? And since then, this theory has become extremely influential. Judges have taken on Judge Laval's framework wholeheartedly. So what is that framework? When applying that framework, judges ask 2 questions. First, is your use transformative? Now, transformativeness is a tricky concept. And it's not, you might think of literal transformation. And I found some great illustrations I will include in my next. I was just looking at something this morning. But you might think transformation means literally changing the thing, right? And a lot of art is transformative in that way. And that makes the fair use evaluation a little bit simpler. So if you're an artist and you appropriate a little chunk of a commercial image, like a leg from a fashion photograph, right? And you put that on a canvas with a bunch of other legs, and it becomes clear that what you're doing is not fashion photography because you just have a bunch of legs on a canvas, but instead making a comment on fashion photography and appropriating that photography in the process. Then what you're doing is something new. You're taking the image and transforming it into something different than what it was, and presenting it for a different reason, and adding value in the process by adding your own commentary and criticism. So that's a really simple case. But in fact, transformativeness can be much broader than that. So you can recontextualize something without having to literally sort of cut it up and change the way it looks. And one good example is search engines. So if you do an image search, like in Google Images or Yahoo Images, you'll get a kind of matrix of results, and all those images just are the images, right? They don't change the image, they don't cut it up, they don't. All they do is show it to you with a bunch of other images, just like the image is on the home web page. But they're doing it for a different reason, right? It's in the context of a search. And it's showing you, well, these are all the different images that kind of match what you're looking for, and click on one and we'll take you to where it is. And that's not what the original page is doing. That's a new thing. It's a new purpose. It's adding value. So that's the first prong, transformativeness. The second prong is, did you take the appropriate amount for your purpose? And the value of this part of the test really became clear to me as we did this Code of Best Practices project. Because there's really a lot of work to do in that prong. If you're trying to sort of make your use as legitimate as it can be and withstand legal challenges, this is really where you want to spend a lot of time as well, thinking about, well, why am I doing this? Why am I taking this image? How much of this image do I need to make my point? And how much would be sort of just taking because it looks cool and would make people like what I'm doing more, right? So thinking about, is the amount appropriate? There's another development that's happened over the last couple of decades, though, that's equally important. So the transformativeness test makes fair use sort of comprehensible. It's something that normal people can have a discussion about without having to sort of get into the metaphysics of the four factors. We all have a kind of intuitive understanding of adding value and so on. The other thing that made this sort of Code of Best Practices project really feasible is that it became clear in the early 2000s, thanks to a study done by a professor named Michael Madison, that judges were up to something interesting in these fair use cases besides just applying the factors. They were also kind of legitimizing communities. So Mike Madison studied all of the fair use decisions, 150 plus years of case law on fair use, and found that judges, when they encounter a use in a kind of specialized community, a community of practice, folks that all are working toward a certain mission, and that mission is itself legitimate, right? So you want these people to be in business. So, selling DVDs on Canal Street is not a community of practice that's probably going to get much sympathy in the courts. But if what you're doing is something legitimate, if you're a biographer, right, then the judge wants to sort of let you get on with your business. Judges want to know, what do biographers do? What's legitimate in the community of biographers? And then if that's what you're up to, fair enough. Right? That has a real influence on the fair use decision making that judges do. And that's especially the case when you can put forth the kind of documentation of the consensus of the community. When you can say, look, these are the 9 pillars of our profession as articulated by our leading organization, and so on. Judges care about that because I'm not a biographer, I'm a judge, right? Judges are anxious not to tell artists how to do art, not to tell scholars how to do scholarship. They don't want to intervene in culture if they don't have to. So documenting the practices of communities becomes a kind of legal, a way of doing legal scholarship, of deciding what is likely to be the law of fair use. So along come the best practices codes to implement this way of thinking. And several communities have done these codes of best practice since 2005. Documentary filmmakers were the first. And what happened in the documentary filmmakers case was that they, through Pat Aufderheide, who's a film scholar, she's not a legal scholar, she's a film scholar, but she had all these friends who were documentary filmmakers, and they said, you know, some of them said things are kind of wonky in documentary filmmaking with respect to fair use. There are certain things that I'm afraid to do, and that's a real problem for me. And Pat said, well, you know, let's look into it. And when she looked into it, a bunch of folks said, no, there's no problem. And she said, well, then, now that's a mystery. What's the source of this schism in the community? And she delved a little deeper, and the folks who said there's no problem explained that the reason that there's no problem is that there are some films that they just don't make, right? It's sort of, I'm a professional, I'm a good documentary filmmaker, so I know that it would be foolish to try and make a movie about 20th century music, where popular music is involved. Or I'm a responsible filmmaker, so I know that I can't go film on location in a place where there's going to be lots of ambient popular culture that I'm going to have to just cut back out again. So I just don't even bother to take interview shots in places where there's music playing or posters in the background. And so these guys had a feeling that, you know, there's no problem because we're just stopping ourselves from going forward. It's as if libraries said, oh, there's no problem, we just don't digitize anything in the 20th century. Which is kind of what we heard when we talked to folks. And so after the documentary filmmakers introduced, and so let me talk about a few of the other, there are several other communities that have done this. Scholars of different kinds, especially communications, you know, media studies type scholarship, media literacy teachers, online video. There's a whole code of best practice and fair use for doing these kinds of remixes and mashups and stuff that people do. Most recently, you'll hear later from Gretchen Wagner of Artstor, who's done a fantastic statement on the use of visual resources and images in the context of new work, new scholarship. So this has really taken off. There are more than 10 codes along these lines that communities have made, and the Librarians Code is just sort of the latest iteration. So let's talk about some of the results of that Documentary Filmmakers Code. Films got aired on TV that wouldn't have gotten aired, right? The filmmakers came together, they wrote a code of best practice, and they said, well, nothing's going to happen because nobody cares what we say. But it turns out films got aired, films got made. And most importantly, there is an insurance policy you have to get if you're a filmmaker called errors and omissions insurance, right? Because you will make a mistake. There will be some kind of, someone will not sign the clearance and then they'll sue you. And you need a kind of insurance policy that says if you get sued, we'll pay these people to go away. And so the insurance folks have a very deep interest in making sure they understand the legal risks associated with an activity. And after the code came out, they all started sort of falling over themselves to offer errors and omissions insurance on the basis of fair use. Whereas before, they would require you to show that you had permission for every piece of third-party material in your film. So this became huge. They were competing to see who could charge the least until finally no one was charging anything to ensure fair use. Whereas before, no one would charge fair use at any price. So huge impact in the documentary filmmaking community. So what are these best practices things, right? What are they? What are they supposed to be? Well, first, they're principles and not rules. So Jim Neal said earlier that we should love ambiguity in some ways and in some contexts, and I can't actually agree more with that. And in fact, somebody pointed out to me, I gave a similar talk at MIT the other day, and one of their general counsels pointed out approvingly that the word appropriate appears more than 10 times in the code. And that's not an accident. That's not an accident. That is, there is wiggle room in here because different things will be appropriate in different contexts, and that there needs to be that wiggle room. It would not be a service to you or to the fair use doctrine to give you something that purported to draw bright lines where there just aren't any, and where the presence of bright lines can be a real detriment for folks. So they're principles and not rules. There are limitations to the consensus that we found when we did this document. I'll tell you a little bit more about the process of developing a code, but these limitations are not meant to be bans on what people can do. They're just limitations on what folks were comfortable saying was clearly within their consensus at this time. And so there's a very explicit hope that this document could become a historical artifact over time. That is, that the community could push past it and do more on different things. What this document is meant to reflect is just how folks are feeling right now and what they're comfortable with right now, and not a kind of golden tablet down from the mountain to tell you what you can do and not do forever. And finally, this document is meant to encourage reasoning and not rote. Along the same lines, as the question of ambiguity is, although there is ambiguity, there is a method for thinking in this code. So it's not all smoke and mirrors and do what you think might be right, and we're not going to help you think about how to think about that. We do want to help you think about how to think about that. So there is a method of reasoning in this document. It helps you think through these problems, but it doesn't give you the answers. And that's not an accident. So why did we do this in the library world, right? Why does fair use matter to librarians? And I probably don't have to tell you any of this, but I will quickly. So fair use enables mission, right? There are aspects of the library mission that just could not be well served without fair use. I like to think of this in terms of past, present, and future, right? So libraries have a kind of duty to the past, right? You are cultural storehouses. There are things within your walls that exist nowhere else. And people come to you for access to culture, to culture of the past. And you're meant to be that kind of, storehouse of culture. And if those things stay sort of embedded in modes of access that no one is interested in, right? Or if they're on media formats that no one is able to access, or that are slowly but surely falling apart, then libraries are failing that mission to serve the past, right? To preserve past culture. There will be copying involved in saving the culture of the past. And to the extent that that copying isn't explicitly protected in Section 108, you're going to be in the world of fair use. What about the present? Well, we heard, and so in the first, we've spent 2 years developing this code, and the first year was just asking folks, how are you doing? What's going on? What's happening in your library? What kinds of questions do you get? When do you run up against a copyright concern? And there's just no doubt that every day librarians are the first line of defense in terms of access to copyrighted material on campus. When somebody wants to do something with that stuff, they ask you. And so when copyright is implicated, and you guys are actually, folks at Columbia are quite lucky to have sort of some experts on hand who are extraordinarily well equipped to help answer those questions, but a lot of folks don't have that resource. And so for some folks, not only are they the first line of defense, they're the last line of defense. They are making these calls and they're out there on their own. And someone comes to them and says, you have the only known you have the only known copy of this thing, and I'm in, the hinterlands. I'm in Africa right now doing research. Can you send me a PDF of this manuscript that you have? I don't know. Can you? Right? And they don't know. But that's a pressing need, and I need it right now. They don't say, like, we'll get an opinion from your general counsel and talk to me in a year and a half, go to your fair use committee, and, it's, no, I'm writing something now, and I have if I can't get this back to my publisher in 6 months or in 1 month or tomorrow, I will not get to publish, I'll not get tenure, I will die in the bush. You need to help me. So, present needs are pressing. And then finally, there's a sort of duty to the future, right? How will libraries stay relevant going forward? When you have to think about what your role is going to be as things are going digital, as people increasingly expect access online rather than in person, as they increasingly expect finding aids that are comprehensive, full-text searches. Why can't I search your library the same way I search Google? Why can't I search it better? Google is a for-profit corporation. They just have to make it good enough to sell some ads. You guys are the pros. I want the best possible searching capability across the library. Make it happen. That's what your users are telling you, right? And to move into the future and to give folks what they expect, again, is going to require copying. It's going to require digitizing. It's going to require doing things that will implicate copyright. I mean, every time you touch a computer, I'm implicating copyright, right? But we found in our year one investigation that insecurity is everywhere, and hesitation is everywhere, and that those two things have extraordinary costs. So there were lots of projects not happening. There were lots of things, lots of cases where someone would say, well, we have X hundred linear feet of boxes, and we would love to make this collection into something that's full text searchable, and we had a grant funder that said they'll do it, but only if it's available to the whole world, or only if the search capability is going to be online on the open web. And we're not comfortable doing anything online on the open web, and so we turned down that funding opportunity, and we're not going to digitize that stuff. Or we started to do it. We spent tens of thousands of dollars to do it, and then we hit a wall at 1923. We hired a college student to try and determine the copyright, whether stuff is in the public domain or not, and he couldn't do it. And when we realized what it would cost to get a lawyer to do it, we gave up and we canceled the project. So we heard that stuff. And we heard that folks understood that fair use would help, but they thought, well, sort of fair use is a license to get sued, right? I mean, there's no, it's woven in out of air. There's nothing I can rely on there. And when there wasn't a strong sense of what their rights were under fair use, a sense that it was really something you could rely on, folks instead turned to risk aversion and risk avoidance rather than risk management. I know that risk management is going to be a big topic today, and I hope it will be. We're huge fans of it. The goal of this document, in some sense, is to make risk management rational, to take some of the fear out and put a real understanding of how fair use can reduce the risk involved in projects. But instead, risk aversion has these kinds of gut intuitions. Risk management is about taking a clear-eyed look and doing the math and saying, is this worth it? Risk aversion is about sort of listening to your id and hiding, right? Put things behind a paywall, put things behind a password wall, never a paywall. Put things behind a password, don't digitize anything after 1923, don't do anything with anything that anyone has ever heard of. If you have a box full of letters, digitize the ones from an obscure person to an obscure person, and put the ones from Frank Sinatra in a box and tell people they have to come and physically find it. So that's the kind of stuff we heard about. So we wrote a code to try and help folks make better choices in these contexts. How did we do it? The same way it's been done in all of the other codes, which is we didn't write it. I'm a lawyer, I'm a copyright lawyer. I could write my code and sort of, anybody in here with a law degree could write their own little code, right? Here's what I think you should do. But as I described to you, what makes these codes legitimate, it has to come from the community of practice, right? If it's written for you, if it didn't come from you, then it doesn't have your stamp of approval. It doesn't get the authenticity and the authority that it has if it comes from the community. And so we went to the community. So we took that first year where we said, what are people frustrated by? And we just translated all those stories into anonymous versions of stories, scenarios, to cover 9, 10, commonly recurring things. And we got together with 90 librarians, not all at one time, that would be crazy. Between 8 and 12 librarians at a time in meetings, librarians from 64 institutions, from amazing, well-funded, well-supported folks who came in with a swagger and said, here's what we're going to do, to folks that were out there really struggling and scraping on their own, saying, well, this is the best I can do. And they taught each other a lot, right? They had a lot to say, and we had 4-hour discussions with these groups. So we get 10 people in a room, we talk from 8 to 12 or from 1 to 5, and we would just bang out, what are some solutions to these recurring problems? What would you do? What's a legitimate way to solve this problem that is motivated by your commitment to the library mission and keeps in mind the role that libraries play in the sort of content ecosystem, that is, to be fair, right? Libraries do buy the things that they collect. It is not the case that libraries get to have everything they want for free and never have to account to anyone for anything. And librarians have a really strong understanding of what they owe to the people whose material they are in charge of. In fact, they have, an extraordinarily strong sense. That is, we found in the first phase that there were people who were sort of too solicitous of the concerns of their friends on the other side of the table, and were sort of saying, well, I know that I don't have to not do this particular thing. I know that fair use would let me do it, but I feel a duty to continue sort of doing things that I know are not helpful because I want to help my friends. So we got these consensus principles from these long discussions, and we had them reviewed by a panel of outside legal experts, right? Because I'm invested. My wife's a librarian. I work for librarians. I love libraries. Peter has been working with librarians forever, and we've spent 2 years doing this thing. So of course people are going to wonder, can these guys do something, can say something about the law that's objective and defensible and reasonable? So to try and forestall that concern, we brought in 5 outside experts, one from inside of a library, one from University General Counsel's office, somebody from private practice, and a couple of copyright scholars at esteemed law schools, including Mike Madison, who coined this whole movement in the first place. And they looked it over, and they gave it a kind of good housekeeping seal of approval. But what does that mean, right? It can't mean, because no lawyer can tell you that this is good to go, right? Just do this and you'll never get sued. That would be malpractice, right? You can't say that, I won't say that, and these guys didn't say that either. And it also doesn't mean this is exactly what I would tell my institution to do or my client to do, because every lawyer knows they have their own sort of peculiar views of fair use. I have my views, and everyone in this room who has thought about fair use will have their own view. But also, if you're at all reasonable about these things, you know that there is a zone of rationality within which your views live, and other views that are not yours can live in that zone too. And that's all that these experts said. That is, not this is my favorite theory, but knowing what I know about fair use, this is a defensible, reasonable construal of the doctrine. So what do we hope this thing will go on to do? Although I'm anxious to hear from you what you think you might do with it. We introduce these things into the world, but it's really up to you guys to use it. And I might be totally wrong about what you might do with it. But what we hope it could be useful for is to put these legal risks that are perceived to go along with fair use into perspective. In part by taking account of what I like to call mission risk, right? So whenever you're doing a kind of risk management decision, the example I love to use is if you're going to build a building, that building is probably going to have stairs, right? Sooner or later, someone is probably going to trip and fall down those stairs, and they could sue you. That risk is never going to be zero. You can never build a building that no one will fall in the building, right? Or if you could, it might be fun because it would be full of bouncy walls and but it wouldn't be very functional. So to have a functional building, it's going to have to take into account the value of designing the building the way you want to design it versus the risk associated with inevitable lawsuits. And no lawyer would say to a university considering building a building, well, somebody might sue you for that, so don't build the building, right? Or can you just have elevators and all the walls made of rubber and all this, could you go to an absurd expense to make sure that no one will ever sue you? And that doesn't happen, because we all know that it's worthwhile to design a building and you take on a reasonable risk in association with that mission of building new buildings, right? Creating new spaces. The same is true for fair use. When you're going to go forward with a new project in the library context, you should weigh, on the one hand, certainly the risks associated with that, right? What is the risk someone will sue you? What are the odds they might win? But you also need to weigh, on the other hand, what is the value of this project? How important is it to the library mission? How central is it to what we need to do? And we hope that librarians were able to sort of have that perspective as they thought about fair use and formulated these principles. And we hope that this document will introduce a little bit more of a sense of the value of what libraries do into the discussion of going forward with projects. So we hope the views of librarians will sort of enter the room in the guise of this document in places where they haven't always been in the room in the past. Especially, again, at those institutions that can't afford to have a kind of library expert on hand. We hope that this is something that the librarians can say, look, I'm not a copyright person, but look at this. This is what my community said. And along those lines, we hope this will be a kind of grounding for solidarity. That is, again, to have legal force, to be sort of a compelling thing to a judge, and honestly, these things have not come before a judge. It usually doesn't come to that. Most things never come before a judge. It's usually other gatekeepers. It's a general counsel's office. It's an administrator. But in any case, these things are always stronger when you can say, look, every other library is going forward with projects on the basis of this code. They're starting to use it to think about these things. Why aren't we? And so we're hoping it would be a grounding for solidarity for folks to sort of rally around these norms and these common practices. So I've got just a few minutes, and that's fine, because I don't want to get into the details of these principles and down in the weeds with you guys today. I just want to give you a flavor of what's in here, and I hope that you'll get down into the weeds and look at what's in the code in your own time. So these are 8 common situations where fair use could apply, and we discussed these with the librarians, and they came up with codes with principles, limitations, and enhancements to address these situations. So the first is providing digital access to teaching materials for students and professors. This is, again, the principle that deals with course reserves and course websites, things like Blackboard and Moodle, and e-reserves that are administered by libraries. And there was a strong sense that the use of these tools can be fair when done conscientiously, right? And everyone's doing this. There's this very strange sense that, I know that, so the Georgia State case is happening. Georgia State is being sued by a couple of academic publishers. Those publishers aren't paying their own legal bills. The Copyright Clearance Center is paying half, and the American Association of Publishers is paying the other half. So Georgia State's being sued by CCC and AAP, essentially. And there's a sense that Georgia State must be way out there, but in fact everybody's doing course reserves in some way or other. Right? This actually is a very common practice to make some materials available online, and it's happening here at Columbia. It's happening everywhere. So it's not a strange thing to do, and the question is just how do you tailor your practice so that you're within what's reasonable in the eyes of your community. And so that's what we tried to describe in the principle with the limitations and enhancements that are there. So the second principle deals with mounting exhibits, both physical and virtual. And this was something that we didn't anticipate talking about. In our infinite wisdom, we had sort of thought we'd identified 4 or 5 things that would be the things that this would be about. And this came up out of nowhere. We sort of didn't realize, but people, in libraries are mounting exhibits, right? And they want people to know this is what we have in our library. And when they mount a physical exhibit, they want there to be a virtual counterpart, and they want that counterpart to live on the open web. They want it to live kind of forever, even when the physical thing goes away. And there are copyright questions associated with doing that that spooked people. And so, again, we tried to address that. This is a great example. So I have an example for each one. I thought this was fascinating. So Alexander Gumby's African America. This is a collection here at Columbia where someone kept a scrapbook, like a series of scrapbooks, hundreds of scrapbooks, and he cut out sort of all kinds of things from newspapers and books and clippings of all kinds related to the African American diaspora in America and the struggle for civil rights in the early 20th century, the Harlem Renaissance especially. And these clippings he didn't write them, right? And yet there they are. And they're in a certain context, they're in a collection. He collected them. The fact that he collected them means something. But he didn't write those poems. So even if his estate gave the library all these books, they couldn't vouch for anything in them, right? I mean, they didn't write that stuff, but there it is. And if you want to do that kind of project, asking permission for 300, journals full of clippings, it's never going to happen. It can't possibly happen. And so fair use has got to be available to you if you're going to try and do something this ambitious. The third principle is digitizing to preserve at-risk items. And this is a kind of 108 plus scenario, right? So students of copyright in libraries know that Section 108 is the specific exception for libraries. And they probably know that it's been an open secret for years that Section 108 is terrible and outdated, right? It just is not compatible with the digital reality that we're living in now. The number of copies that it authorizes is too small. The strictness with which it limits which things can be preserved is too limiting. You have to wait for something to be actually broken or degenerated or lost or stolen before you make a copy of it, which is like kind of physically impossible depending on what kind of thing you're talking about. And in fact, in a recent Copyright Office proceeding, a music librarian from the Library of Congress said to obey Section 108 would be malpractice, right? To live within the means of Section 108 when it comes to like an Edison wax cylinder would be insane because it becomes unplayable the minute it qualifies for preservation under Section 108. So it must be the case that there is a kind of zone of preservation beyond Section 108. And we found, again, a consensus among the library folks that there was. That preservation is not the same as selling DVDs on Canal Street, right? It is a legitimate library activity that is adding value, preserving culture, and doing something new and different. And of course, right, when you can't buy it, right? I mean, there are some reasonable, those are the kinds of limits that are in the code. So of course, and people think librarians are so crazy. Why would you digitize something if you can buy it on DVD for, you know, almost nothing? It costs so much and takes so much time to make these copies. You know, of course, if you can get it in a digital format, you would. And that was something reflected in the consensus that we found. So there's a room full of VHS tapes. That's kind of a paradigm case of what we're talking about. I don't know if you know this, but VHS tapes are not obsolete. It's news to you unless you're a copyright lawyer. Because you can find a VCR somewhere. They're still being made. You can buy one. Now, they may not exist on your campus anymore, and no one is willing to use them, but they're out there. And Section 108 says if you can buy a machine that'll play the thing, then the thing is not obsolete. Our librarian said, surely that is very strange, and fair use can swoop in and sort of save the day. The fourth principle is about digitizing special collections and archives. And again, this is a context where you guys are holding unique, rare, fascinating stuff, and how are you going to make that stuff findable and accessible in the modern era? And there was a strong consensus that surely to do that has got to have, there has to be a realm of fair use to make that happen. And so Columbia has a fantastic collection of corporate reports that have been digitized and made available online. It's a special collection. The stuff is historical. It's gone. Its original purpose was, right, to inform investors who might be thinking, you know, is it good to buy stock in Buggy Whips this year? And it probably says, yes, do. And that's really not the purpose anymore, right? If you buy stock according to these reports, you're going to come out probably pretty far behind the market. And so this is something new. The library is really facilitating something new by enabling scholarship based on this stuff, rather than just, you know, they're clearly not just sort of ripping off the original publisher. Principle 5 has to do with access to research and teaching materials for disabled users, and this is another case where there is a specific exception for it, Section 121, the Chafee Amendment, and it is notoriously narrow and outdated and strange and hard to apply. And there's been a kind of concerted effort by the publishers to misconstrue it. So they've told libraries over and over again that you're not the kind of institution that even qualifies for Section 121. To use Section 121 to make copies accessible for the print disabled, you have to be solely dedicated to that mission. And because universities also teach and do other stuff, they're not sufficiently specialized and dedicated. So there was a feeling that there's room under fair use again, where the stuff is not being made available. If the publisher is not on the market making accessible copies for folks, that part of what a library does is make materials accessible to their users. And that's the DAISY Consortium. They make readers. right? That everyone, that folks can use to make material accessible. But those readers, obviously, you don't just sort of plug a book into it. That book has to become a digital thing before it can become a DAISY thing, and that's where libraries can come in. Sixth principle has to do with institutional repositories. It is increasingly popular, right, for a university to try to collect and store the scholarship that it generates, whether in the form of theses and dissertations or local scholarship by their own professors. And some of the vendors that provide access to these materials have had very strange contracts that say, you know, do you hereby swear and warrant that you have permission for every piece of material incorporated in this work that you didn't write or create. Which means if you have like a block quote from another writer and you're a paranoid PhD student, which by then you typically are, you are going to freak out and just cut the quote out because you're never going to find that person and they're not going to give you permission. Or you have hundreds of quotes and you're never going to find all those people. And so you just start blacking stuff out. And so we heard about institutional repositories that are these kind of, you know, Swiss cheese repositories. And there was a strong consensus that if you're providing a good basic introduction to fair use to your students and your professors and helping them understand their rights, and then they go forward and write something that incorporates third-party material relying on those rights, that libraries can stand by their users and ingest that material into their IRs and help them sort of stand up to the vendors. The seventh principle has to do with what we in the biz call non-consumptive uses. And that's stuff like search engines, where you're not trying to read the book, right? You don't want access to the whole book. You're not trying to read any one particular thing. What you're interested in is facts about huge collections of things. Right? And in fact, there's a good argument that you don't even need fair use, because what you're doing here it does not implicate copyright at all, because you're interested in facts about stuff, not the expression in the stuff. But at any rate, you're looking for words, you're looking for parts of speech, the recurrence of particular modes of expression across tens of thousands or millions of texts. And if you're doing that kind of thing, you're doing fair use. And this is actually the most strongly supported, this is actually the most strongly supported principle of the bunch, I would say, because there's explicit case law that says, you know, for something like a search engine, ingesting copies and using them as the basis of a search engine is fair. Companies have built billion-dollar companies relying on this, right? Google's whole life is at stake. They are relying on fair use. Google will be out of business if they can't scan the web, right? And I mean, you probably know this because you're all librarians, but you know, when you search Google, you're not searching the web, you're searching Google, right? When you type in a word, you're searching the local copy of the web that lives on Google's servers. And they're just copying the web all the time. Copying millions and millions and millions of pages. And they never ask anybody's permission. And they're relying strongly on fair use. It's not a coincidence that Google is in DC always fighting the good fight for copyright and fair use. It's because there's millions of dollars at stake. I mean, they're very nice people, but there's millions of dollars at stake, and they're going around the world fighting this fight. They're trying to get fair use in the UK. They're trying to get fair use in the EU, because millions of dollars are at stake. It's not a coincidence that these innovative things happen in the US where the fair use doctrine exists. So, for example, here's a search on Google Books, and this is not the Google Books. This is not the Google product. All right, Google lets you search their books in a certain way, but this is actually a mode of searching. I don't know why it says this was made in 2009, but this was actually a way of searching Google that a linguist, an academic linguist, has created. It crawls the same corpus, but it's much more fine-grained. You can do much more interesting stuff with it. But you'll see that I wasn't lying when I said fair use got much more interesting in the last couple of decades. All right, that's the incidence of fair use since the 50s, 70s, when it was created, into today, and it sort of doubles and then triples and then quadruples, right, in the last few decades, because it's become so important in our digital culture. The final principle has to do with harvesting things from the web. And the question here was, right, can you collect things from the web, not the way Google does just to make it searchable, but to really collect it and maybe make it accessible to scholars in the right context? Can you copy that stuff from the web and probably without asking permission because, frankly, you don't have time. There has to be a kind of fair use rationale here because these folks typically are gone before you can ask them. A lot of the sort of small website administrators that you might ask to grab their stuff. And the question was, you know, is this entire medium just going to be not collected by libraries because of these quirks of copyright, or can libraries go forward with their business based on a fair use argument? The answer was that they could go forward. And so this was our paradigm case. This was actually the case that we talked about with the discussion groups typically, was, you know, the Human Rights Web Archive here at Columbia. It is fantastic, and it is collecting stuff that is so ephemeral. You know, if it's not captured in this archive, it will be gone. No one will ever find this stuff again if it is not sort of diligently cataloged and kept by libraries. So this is a huge service to culture. And it's something that obviously is very different from the mission of the author, right? You're really transforming you're really transforming this stuff in the sense that you're creating a cultural archive for scholarship that is completely different from what the author has in mind. You know, the author wants to agitate on behalf of his or her cause for a few months and then disappear, and you want to make it available forever. I mean, you're kind of thwarting the author, right? So in this sense, you're really up to something different. So those are the principles. I really hope you'll turn to the principles and especially look at the limitations and the enhancements. You know, these are broad sounding sort of go forth and do this, but the meat that's going to help you decide when to do this is down there in the enhancements and limitations that are associated with each principle. The moral of the story really is that practice makes practice, right? The more you do this, the better you get at it, the more comfortable you are, and the more your rights actually sort of accrete over time. Fair use is a muscle is the old cliche that we always, every lawyer, if you ever hear talk about fair use, you'll probably hear that. Fair use is a muscle. And we hope we've given you kind of like a workout book here. This is like the fair use, you know, abs diet. Sweat into the fair use. So there's more information available. So we have a lot of stuff on our website. The code, I think, stands on its own to a large extent, but we've honestly tried to give you everything you might want to help you as you're working through these questions. So if you go to arl.org/fairuse, you'll find archives of these presentations that we're giving around the country. You'll find FAQs for students. You'll find presentations that you as librarians can give to students or to teachers in your institutions about fair use and about how they play into this ecosystem. This is the book that Pat and Peter recently wrote that kind of describes their story and their history and gives you a kind of blueprint for doing these codes in any community. So, you know, if in your spare time you're a coin collector and you're thinking coin collectors have copyright problems, you can just go make a code, right? There really is kind of a formula. There's a way to do this, and you can do it in your own community. Please share this thing in its entirety. It's all these presentations are posted on the web. You have our permission. Use it. And, you know, excerpt under fair use. Thank you so much. The Andrew W. Mellon Foundation was a huge supporter for this project. Without their help, it wouldn't have happened at all. So they're hugely important. And to research librarians, hundreds of you have helped us do this thing, and many more hundreds of you have participated in the rollout process. And we really hope that we can help you as much as you've helped us, because you've helped us immensely. That's my contact info. Don't hesitate to write me. As Kenny recommended that you write down questions, and if you have questions that might be appropriate for me to help you with, please do. Just like Kenny, we want to keep our website up to date with FAQs, and so if you have a Q that might be FA'd, please contact us, and that's it. Thank you all so much for your time.
Lisa comes to us from Seton Hall, where she has had the task, well, I just can't help but make comments about your research on monkeys and what this might mean for fair use. But we won't go there.
Monkeys don't sue.
Monkeys don't sue. They throw things at you, but they don't sue, right? Yeah. And so Lisa brings her diverse experience to the task of heading up copyright initiatives at Seton Hall, and is now going to reflect on some of the law and background and cases and examples and real people, and talk about how to move forward and what you need. And so let me click one button here, and Lisa, welcome.
Well, thank you very much, and thank you to Kenny for inviting me. I'm going to start off by the disclaimer that I am in no way, shape, or form licensed to practice copyright here or anywhere else. I am, as Kenny said, a behavioral ecologist. I used to study monkeys, reinvented as a librarian, and the fact that I'm here is a direct result of that well-known academic law that if you grumble that something should be done, it's tantamount to volunteering to do it. And hence this long, lumpy copyright committee. We usually call it the Copyright Action Task Force, actually. But can everybody hear me okay? Is this positioned all right?
Yeah.
Good? Okay. So I was wondering, actually, while Brandon was talking, how I was going to segue into my little story, and he actually gave me the perfect opening by saying that there are many libraries out there who do not have the benefit of a copyright office like Columbia has, or even a copyright officer, or even a copyright policy. And we were one such library. We were, in fact, particularly the reference librarians, the first line and the last line of defense. And when I started at Seton Hall in 2008, basically the way we dealt with copyright questions would be something would come in, and if we didn't know the answer, we kind of look it up and ask one another. Usually our access services librarian fielded a lot of the questions. And we muddled along okay until this critical incident, as I call it, happened in 2010 and fell into my lap because I was on the reference desk at the time. It wasn't presented as a copyright question. In fact, the professor who asked for my help in creating a database of articles so that her colleagues and students on and off campus could have instant access to it was very taken aback when I expressed some reservations in terms of copyright, that maybe this was not something she should be doing, and she was very annoyed. And that leads me to the other kind of issue to point out that I too can appreciate the joys of copyright and fair use as space for creativity and being gray and ambiguous and slippery. But users like faculty and students and staff and the public, they want black and white answers now, okay? Yes, you can digitize 20 pages. No, you can't digitize 21. That's what they're looking for. And they're certainly not going to be looking to be told that we don't think you can do this, but we'll have to meet about it and I'll get back to you. So sort of similar to your fellow in Africa analogy. I doubt that she would have died in the bush if she hadn't got a database. Similar kind of thing. We can talk later about whether this, what you wanted to do, was actually feasible or permissible, but the point is that none of us knew. I had reservations about it. Half the people I asked, yeah, that's okay, it's library content, she's just putting in links. Others said, oh no, you can't do that. There's also the whole licensing aspect. So finally we called a meeting with our dean, who was not a librarian. We had an interim dean at the time, but certainly recognized the problem. And with IT, who deal all the time with takedown notices and illegal video streaming and things like that, to see whether or not this could be done. And really what came out of that was I grumbled very loudly about we really need policies and guidelines and somebody whose responsibility this is. Our access services librarian had left for another position, and due to the downturn in the economy, so-called, hiring freeze, he was not replaced. So the advent of all this was, I'm grumbling about this, form a committee, you're it. Also at the time our digital services librarian, who was probably the most savvy person about copyright, was volunteered as my co-chair. She didn't know it at the time. So we moved forward with this get a copyright committee going draft. After extensive searching, it was lost. I guess it had not been digitized and preserved. So, okay, we're going to write a policy. And it sounded fairly straightforward, but very quickly it was apparent how complex this was. Because, of course, we were dealing not with just the obvious kind of course reserves type of situation that I had come up against. You know, it's interlibrary loan, it's licensing agreements with databases and journals, it's digitizing, we have an institutional repository, we have a gallery, we have an extensive archives with a lot going on. There's all types of questions that arise that would need to be covered. The other problem was that at the time, you know, the Georgia State case, this was back in 2010, was all over the news. We were that example that Brandon referred to of, we were nervous. especially when we had nobody to turn to. It was just us, and ultimately sort of my backside on the line if I did something wrong. The other problem was that I think, as at most academic institutions, you know, bureaucracy is rampant everywhere, we all know that, and trying to get something done at the level of a policy, which the upper administration takes very, very seriously, you know, it's like a legal document, we did not really know where to turn for help. Everybody agreed this needs to go higher up the food chain, this is beyond our scope, but we didn't know where to go. And to compound that problem at the time, again, because there had been such cutbacks in budgets for academia everywhere, we had a lot of reshuffling at the top. There was a big reorganization in administration. People that we had known had suddenly moved elsewhere or been let go or gone to other places. I did make contact with one high-up person who had legal background, who I thought would be great, and we corresponded several times. We were due to meet, and she had disappeared. So there was this big problem of this being beyond our expertise, but also where could we get support? I should add too, now we have a faculty member from our law school on board the committee, and we're hoping that that will help us move forward, as he is much better trained in that area than we are. There's also the problem with any committee of people in academia. You know, these are very busy people with multitudinous responsibilities, and just trying to get people together can be difficult. So that moves me to the kind of big what libraries need kind of question. And that's one of the first things I'd say is we need support from our administration to recognize that this copyright issue is important, and if libraries are going to engage it, which we kind of de facto are, we need some support, including some financial support. Because the big thing that's lacking, I would say, in our institution and probably in others, is what I'd refer to as dedicated expertise. Somebody whose job this is, somebody who's comfortable making these decisions, particularly in those, you know, you're on the firing line, the faculty member wanting an instant answer, somebody that can give that answer, not get back to you 3 weeks later. Of course, the ideal, and you're probably all going to laugh at me unless you're from very wealthy institutions, is to hire a full-time, you know, very deeply copyright-savvy librarian, preferably somebody with a JD. That would be my expectation. Of course, those of you who are librarians know about our salaries, and those of you who are JDs know about yours, and I suspect there's a big gap between the two, to put it mildly. If we can't get that, which would be, you know, a wonderful thing, but kind of in these economic times, maybe not that feasible, I think something that would really help would be to give support and training to existing librarians so we can at least better get a handle on this type of material. And in this case, yes, you know, the guidelines are very helpful. I'm sorry, I should have said best practices, not guidelines, shouldn't I? Are very helpful. But I think there's still no substitute for actual in-person training, and that's something that I think ARL would be able to help with. You know, maybe having workshops in different areas that we could actually get to. And along with that comes, and again, harking back to the administrative support, the recognition that that also involves release time for librarians to be able to do that. In librarianship, I've noticed, even more so than in my past life as a teaching faculty, there's this huge assumption that another job comes along and the library takes it on, and the librarians just take on this additional job. They don't have any less work to compensate, it's just another thing on top of another thing on top of another thing. And ultimately, I think that doesn't really work to our best advantage. We end up so finely divided and so overloaded that we really can't give something new and complex the attention that it deserves. So that would be my other thought, is in terms of not just support, offering training and offering resources to turn to, which is wonderful, there needs to be some kind of financial bottom line here. At some point, money is going to have to be put into this question if librarians are going to do it, whether it be hiring new people, training existing people, giving release time. There is a question of, I'd say, financial accountability in order to help create the expertise that we really need. And that's my report from the trenches. That's what's going to give us confidence in being able to exercise our fair use rights, is knowing what we're talking about, you know, is having a really deep understanding of this. So yes, the best practices certainly helps, but I think there's a lot more that we on the firing line need before we are comfortable to standing up to the bullets, shall we say.
Excellent. Thank you. And so Brandon, I'm going to give a point of privilege to the committee, to the panelists, and Brandon, I'm going to allow you to ask Lisa a question if you have one.
Now I'm really on fire.
No, not at all. I mean, first I should say, I agree with you entirely about everything you said. And in fact, we included some things in our report after the first phase of this talks about challenges libraries face, and we really tried to hammer in the value that a staff person 100% dedicated to this could add and stuff like that. So I totally agree, and I'm just curious because I want to know how can we help to make these things happen. So one thing you mentioned was that ARL could provide like seminars and training, and I can tell you we're working on that. That's coming down the pipe. Is there anything else that we could do in connection with this best practices stuff? What kinds of resources would you like to see? Is there anything written that we could generate that would help you in addition to the code? So the code goes a certain way. Is there more that you could see in writing, or that's what I can do?
Yeah, there's actually two things I could think of. And one would be, given that we are still trying to develop an actual copyright policy, if there was some kind of template for that. I think what we all do as librarians is we look at other libraries' website and see what other librarians have done, and sometimes we go round and round and round in circles. We do that with our research guides and that type of thing. The other, and I don't know if this is feasible, if there was some kind of hotline or somewhere we could call for rapid answers for these complex type of questions. I mean, I bother Kenny if I have a copyright question.
We're just going to put Kenny's number on our website.
No.
Yes, instant messaging.
Oh no. We'll keep the camera on the panel. Now, being a teacher, I like to pick on the people in the back row, so I'm going to turn around and see if there's anybody I had my back to. Questions? We're going to throw it open for questions. Yes, please. One here, and then I'm going to jump to a different part of the room. Go ahead. Yes, go right into the microphone. Brief question.
Hi, yes. My name is Loida Garcia. I come from Queens Library. It's a public library. But I am curious about the guidelines or practices. Number 8 refers to web-based materials and how that relates to social media, perhaps, and Pinterest, let's say. That's really hot right now, and I wonder what are your thoughts about that?
Social media, Pinterest.
Yeah, so I mean, you know, we'd be getting down in the weeds, as they say on the Hill when you start talking particular policies. But most social media websites, sadly, and Pinterest is a perfectly normal example of this, have terms of service. And so, like when you join the site, you explicitly agree to do certain things and to represent and warrant certain things, and when you navigate to the site, you agree to... And so that can complicate things, right? It's not just like a normal website. It's a website that creates a kind of contractual relationship with its users. And so that can complicate things. That can make things more difficult. Pinterest, I would just like to just say, Pinterest is not the next Netflix. I mean, Netflix, it is the next Netflix. It's not the next Napster. It's not any different than Tumblr or any other social media website. There's a lot of copy fear going on out there about Pinterest, and I just don't see why.
I want to say something very, very general now and capture a thought about decision making. You know, one of my slides, I had the picture with the different arrows, and the point of that, I know that's a bad pun, point of that being that there's fair use, there is Section 108, there's permission, there are different paths. And another one that you actually just added to that list is contract. That sometimes the law says X, Y, and Z, but guess what? The rules change because you entered into a contract or terms of use or something else. So we may not even get to the fair use question because of some of these other intermediate steps. Jim, you want to pick somebody from that side of the room? Or?
Yes. I need this one on, please.
Either that or you can paraphrase. We'll
Yes,
paraphrase.
I will. I think it's very important in the contract environment that we negotiate very aggressively and try to guarantee capacity and capability which exceeds fair use in the contracts that we sign.
Hi, Shelley Warwick, Toro College. I want to say a couple of things. One thing that bothered me was everybody disclaiming that they have no right to practice fair use when that's a right everyone has.
That's right.
And secondly, I think one of the suggestions that we do, that maybe we need to look at a fair use consortium where rather than each library trying to have an expert, resident expert, or trying to call Kenny, is that maybe we need to look into consortial organizations where either regional consortiums or tiered consortiums by type of institutions retain somebody who can provide this type of advice, which could be funded, from a group, because we're doing a lot of outsourcing or consortial areas in other areas, and I think this might be something we need to look into.
Thank you.
Can I make 2 comments on that?
Please do.
First comment is that we've built that type of capacity, albeit very modest, in terms of our advocacy work in Washington around copyright with the Copyright Alliance. So there's a model for doing that. The second reaction is very often one of the challenges of doing that on a group basis in terms of thinking about and applying those types of legal judgments is that it's so much built into the institutional culture and the institutional legal interpretations. And so it's good to get information and guidance from somebody like a Kenny, but ultimately it's a institutional decision how much risk they're willing and able to take in doing the things that Brandon has outlined here. Yeah.
If you had an somewhere as an expert to go to for smaller groups to give you the guidance and say these are the risk questions, then you can make a more guided decision.
Yes. As long as it's guidance and not billable hours, that's good.
I like to move around the room. So somebody in this part of the room, yes, please, right here. And you may use the microphone, or I'll paraphrase.
I'm most interested in either print reserves or electronic reserves, and I feel that it's great to have fair use. I think it's a very good thing to be able to make deep links to scholarly articles wherever possible, although every so often I'll come across a title, such as the Harvard Business Review, that says that its license does not include that, and you have to be aware of that. But what I'm more concerned with is the expediency of time and the fact that very often we are given assignments to make things available for the students when it's really serendipitous, spur-of-the-moment kind of thing. So I think, one, we have to have a consensus across even the globe as far as protecting us so that each institution doesn't have to relive this kind of conundrum each and every semester. And secondly, to really and truly look into the newer ways of making, they used to be course packs, but now they're e-textbooks and such that are legitimate and they're contracted, and forging on instead of perhaps getting hung up with the legalities of copyright, having better contracts from the get-go, better licensing, because otherwise it does become a game of lawyers, and my dad's a lawyer, thank God, but I don't respect that kind of game, not in scholarship, not as a librarian.
Thank you very much. And while we're getting the next question, I'll say a couple of comments in general. I'm sympathies with you entirely. But what I'm hearing a few things. I'm trying to distill pieces. And I hear a few things. One, again, is a reminder that yes, there's fair use, and I think we'll always need that. But a lot of what we're trying to do in certain contexts, e-reserves, is very often defined by licenses, which raises license issues that we just talked about. And how can we as a community come to a better sense of this? There's one more thing I'm hearing. just when you think you've got it figured out, it all changes. And a new way of delivering the content to the students becomes more prevalent, moving away, for example, from e-reserves and course packs of days gone by, and so on. So just when you got it figured out, we got something new to work on. Do you want to comment?
Follow up. I heard you at ACRL in the fall. Someone reminded me, and you mentioned there's even a question of who owns the textbooks or the companies. You might want to.
Yeah, your question was one about who owns this material.
Printed from without the country and.
Oh, well, that's another problem. That's another problem.
do that.
Yeah. Import of foreign works is now in front of the courts. You know, taking the law literally, we may be questioning our use of a lot of foreign-made material. Not foreign-written, but foreign-made, produced physical objects. And that could be a lot of things. I don't want to ignore my panel up here. Comments, reflections?
I would just add, you know, if there's a kind of sub rosa message in the code, well, there are a lot of them, but one of them is think carefully and try to be rational and have policies and do these things in an organized way rather than having fire drills. You know, in our first year, again, we encountered folks that just fair use was a kind of emergency measure. You know, we can't, well, someone comes to me with a problem, I'm just going to sort of wave the fair use flag and go for it. And, you know, that can work sometimes. Or someone comes to me with a problem and it's too fast for me to answer it. I can't get a lawyer. I can't, even when somebody like Kenny is around, I can't get him on the phone and I've only got 10 minutes, so I'm just not going to do it. Our hope is that with this thing in hand, we can avoid these kinds of fire drills by working to develop policies that will help rationalize this decision making.
And Lisa, reflections on that?
Actually, I have a thought to the previous comment talking about who owns content, and this might be a little off track, but one of the big things we're dealing with right now is this switching to ebooks and the inability to interlibrary loan ebooks because you don't actually own the book in the same way as a print book. And that's something where negotiating with the vendor is really, it's not actually a fair use question, it's a licensing.
We're back to contract again, taking control of a lot of this. Jim, you said there was a question at this end?
Erica Gottfried at the Tammet Library, NYU. You were talking about what the libraries need and what might be useful. And what I would say is an additional thing. I would say let 1,000 scenarios bloom, because I think specific situations and how a given institution handles them or a librarian handles them, it's very useful, not necessarily to get an answer, but to see the thinking that goes into it and the principles and actions. So I would think gathering together as many scenarios as possible, in, online obviously, but in a book form with an index, and kind of freshening it up every year as the practice changes, and comments on that. I think that would be very, very useful.
Excellent. Excellent. I think I agree. Thoughts about that? I'm going to move.
I think
to
that's right.
question.
This document is limited to the 8 scenarios that we were able to get to consensus in 2011 in the summer, right? And so it can happen again around other scenarios, and I think that would be a perfectly good thing.
However, I think it's sometimes difficult for libraries and universities to be so open and public about the decisions and interpretations that they've made for fear there might be some legal pushback on them. I'm very fearful what Brandon has shown us, what's going on here at Columbia. No, not at all. Those are informed, legally driven decisions that we've made. Thanks, Fred. I agree with that. But I think there's a concern about risk at the university council level about being too public about the types of decisions we've made at the institutional level, rightly or wrongly.
There's a question over here on this side, please.
I have a practical question, perhaps. We've got copy machines all over the library, as we all do, and we've got the copyrighted notice on each of them. However, we also have machines in our private areas, in the workrooms. We have a faculty member who comes in and copies huge quantities of things. We have not approached him to say, what are you copying? Do we have a responsibility to know whether our faculty members are copying in backroom machines huge quantities of copyrighted materials. Where does the responsibility begin and end in a situation like that?
Now, for the camera, please don't say what institution you're from. Please don't. All right, thank you. Reflections on that?
Well, I mean, there's specific language in Section 108 that tells you how to set up a copier and, you know, put a certain kind of notice on it. And if you do those things, you know, and you're not on specific notice about any particular person, but I mean, you know, I think we all have a common sense notion that, right, you want to intervene at some point when things are getting crazy. Be reasonable. The law is not completely an alien construct. So.
The other thing is to make sure there's not too much paper available at the copier. That's a tactic I've done.
One thing, actually, that brings up a great, not the paper thing, although that's fantastic. Practical advice like that is worth a ton. But that actually brings up a question that comes up a lot in the context of these discussions, which is, if I do something in line with the code and in line with what my university policy is, right? We've made a reasonable judgment. Let's say we put something, especially it comes up in connection with the internet, right? So you do a virtual exhibit, and part of that exhibit is an excerpt from someone's manuscript, and that manuscript has an illustration on it, and you put it up and you tailor the size of it all makes sense. You've got a very good story to tell about why it's there, and in the context of your use, it's totally legitimate. And then some rapscallion comes along and takes that thing and puts it on a t-shirt and starts selling it. Can somebody sue you for that? No. No, they can't.
Well,
right?
They could.
Well, right. Anybody
win?
can sue anybody for anything. That's right. And not only can they sue you, they can definitely send you a letter. Boy, letters are cheap, cheap, cheap. So don't be scared about, oh, I got a nasty letter. And nothing can sort of stop people from being irrational. But the standards for secondary liability for copyright are actually pretty high. I mean, you've really got to know that somebody is going to abuse the material that you've made available. You've got to be benefiting from it financially or be able to control it directly. And that's just not the case in the context of these legitimate library uses. And the law is not, I like to say the law is not crazy. It sometimes seems crazy, but if you're a good person doing the right thing, the law is not going to fine you through the roof.
And there's so much more that we could really analyze. It seems like a common situation. We could analyze it all day long. But I'm just going to say one thing. You know that notice that's on the other machines? Put it on that machine.
Yeah, exactly.
Okay.
Good.
Good. Thanks. There was a question at this side of the room. Yes.
Janice Pilch, Rutgers University Libraries. Much of the discussion so far has been about the need to get answers on copyright questions in universities and libraries. And yet, we know that there are many situations in which the Office of General Counsel and the lawyers who work for the libraries and librarians who are copyright specialists really don't want to and don't provide direct answers when they get questions from faculty and students because there's considerable hesitation to do so for legal reasons. This really leads to another question. Are we asking for something that we can't provide to faculty and students? It's one thing if the library needs to make a decision on whether to digitize a certain collection. Another if you get a question from a faculty member asking, may I do this or not? Is it legal or not? Is it fair use? I'd be interested in comments on this.
Absolutely. So there are actually several places in the code where, in the context of libraries serving users, so for example in the course reserves in Principle 1, in the context of, I believe, serving the disabled, there are places where the code suggests very strongly that libraries do work to do some education of users about fair use generally. That is, help them understand fair use, how it works, and again, if at all possible, have somebody on staff whose job it is to make that happen. But if not, have a committee. Find a way to make this information available because if you'll remember the sort of two-step, right, the transformativeness analysis, librarians are often not in the best place to make that evaluation of something like a request for e-reserves, right? Like you don't know why the professor wants to put something online. You don't know how they're teaching their course. And so part of what the code does contemplate is that libraries will have to defer to users in some contexts, but not without first educating them. And so you can't say, in this case, what you're doing is, go for it, this is transformative, or go for it, this is fair use. But you can say, these are the factors to consider. And we've actually provided an FAQ on the ARL site, one for students and one for faculty that we hope would be useful to help them know more and dispel some bad myths, and provide them the resources and the tools that they need. But then you can't hold their hand for the last 10 paces. You have to let them make those calls for themselves, knowing that you've done the work ahead of time to make them confident to make those calls.
Mm-hmm. And I'll take the liberty, too, of confessing something. I'm one of those lawyer types who gets a lot of questions. And for a long list of reasons, I try to say, take a look at the website. There's materials to help walk you through that. Now, I have a long list of reasons why I do that. But one of those that I feel that's hard to relate to if you're not in the position feeling this, and that is that I can listen to you or read your email about, here's what I'm doing, ... Am I within the law? And it might be a situation where I can feel at least 90% sure that I know what the answer is. But I'm still reluctant to say yes or no. And the reason why is I know that there's more to the story than I know already. I just know that. Every situation, there's more to the story. I can't say yes without opening a file, you're becoming a client, laying it all out on the table, reviewing everything, having a meeting. And you know what? That's a lot of time. That's a lot of time. So saying yes or even saying no to something is an act of enormous responsibility. And I have to exercise that judgment very carefully.
That's right. And I think, and if I can add, I think a lot of people interpret that, I feel the same way. I'm doing these panels all over the country, and every panel involves someone asking me, this is what's happening on my campus, is it fair use? Right? And as you can see, I dance and dodge about that stuff for the reasons Kenny just described. But I don't want folks to interpret that to mean that there is no answer, or that fair use is so unreliable that even a lawyer, you might make the inference, fair use is so unreliable that even a lawyer can't tell me yes or no. And I'm not a lawyer, so forget about it. But the reasons that Kenny just gave for not being able to tell you yes or no are not that he doesn't know the law well enough. He knows the law as well as anyone in this room. It's not that the law is too complicated. It's that your situation is only best known to you. And so, I don't want for folks to feel that, when they hear these kinds of dodgy, well, I can't tell you 100%, that it's because you can't make the decision either. It's because you're probably better placed to make the decision than I am in that sense. You know more about your situation than I do. And so I can give you all the legal tools that I have, but I can't tell you your situation better than you know it yourself.
Mm-hmm. Jim, did you say there's a question over here?
Two over here, yes.
Okay. And then we'll come back over here. We're down to a few minutes, so keep
Okay.
it focused. Thank you.
Sure. Ronnie Sacco, and I am not a librarian. I'm part of a team that generates course material for the business school here at Columbia. My question is, Brandon, maybe your interpretation of when one crosses over the line to being a truly commercial entity. We just started charging, not very much for the material that we produce, and we've become incredibly risk averse because we kind of feel like we are no longer protected by fair use as a result of doing that. And as I'm listening to this, we're still a part of a not-for-profit organization. We don't make a profit. We just happen to, charge a bit of money now. So can you maybe provide some insight about when one crosses the line and we lose our protection, so to speak?
Sure. So, right. It's a good question. There actually isn't a line, I should say, first of all. It is not the case that, as I said, right, Google makes more money than God at relying on fair use. Right? So it's not the case that you have to be a nonprofit to make fair use. what gets tricky is when you're relying on sort of standing in the shoes of your user and what they're doing is fair, but you're charging them to help them do it, and it starts to get further and further out. But the main piece of advice I would want to give you is that there's not a line, and so you shouldn't think of it that way. And instead, I think it's actually quite significant that you're not making a profit. You're not charging to make a profit. So you're charging to just recover cost, or you don't even do that. Yeah. So I mean, in that case, I would say you have a pretty good story to tell about why you're charging that is consistent with a fair use rationale. And so I wouldn't be too worried. Again, keeping in mind Kenny's caveat that only you know your situation, as somebody might be secretly taking that money and spending it. But it sounds like you're on sound footing.
It's important to note that there's no hard, fast line. And I think that we've become more risk-averse thinking, oh my God, the minute we charge a penny, all of a sudden it no longer applies. So that's good to know.
Let me say that for decades, we've used this principle of cost recovery to do a variety of things in libraries, not just putting materials on reserve or related to a course, but interlibrary loan. There have been libraries that have exercised their ability to share materials, often under 108, but nevertheless, the whole copies to users environment as an exception, we have charged people for the cost of making those copies. And we have charged people for the staff cost in moving materials back and forth. So I don't think that's an unprecedented argument.
Yeah. And so a couple of bullet point bottom line issues here. Charging does not necessarily obviate fair use. Second bullet point, a lot of the major players spending a lot of money on lawyers litigating that what they're doing is fair use are in fact for-profit commercial entities. Major publishers, for example, are the biggest champions of fair use. They're spending a lot of money on lawyers arguing their case in court. The very same ones, by the way, that we sometimes hear from against fair use. Right. So fair use does apply even in a commercial setting. I think we're down to about a minute.
One here and one there.
And one there you saw. Okay.
Yes. My name is Peter Bay. I am an interlibrary librarian here at Columbia. I just make a quick comments on that. Today we are talking about us as a consumer of copyrighted materials, but we are also the producers of copyrighted materials. And as a librarian, we deal a lot with other producers of copyrighted materials. So if you ask who owns the copyrights, especially for the academic articles, there are a lot of other stories. I mean, we pay the copyright fees to the copyright clearance centers, but the money goes to the authors or the publishers. So as a librarian's position, I suggest, or I wish, we remind us and other patrons that their rights as copyright owners and open them, as Brandon did today after his presentation, open the contents to everyone. And we don't have any concern on this.
Yes, please do. Hugely important.
Yeah, and then Jim, did you promise somebody else a question?
You have one there.
Right here. All right. I think there'll be a last question before break. Go right ahead.
Dean Lance, Columbia Law.
Wait.
Dean Lance, Columbia Law. I'm not a lawyer, but if you could give a brief overview of the Georgia State case and what the, just in 2 cents, and what are the ramifications, consequences, benefits of the decisions, either way.
Well, let me say what it means for the code, because I think it's important. Because we worry deeply that folks will think, yeah, and in fact, this is the sort of stated position of the AAP. They were recently asked, Mike, was it you? Somebody recently in an article was able to get in touch with the AAP and ask them, so what do you think of this code thing? And they said, code schmode, we're waiting on the Georgia State case, who cares what they say? And I think that's a very strange thing to say for a few reasons. First off, so the Georgia State case right now is in the district court in Georgia. That is step 0.5 of a long process of litigation. We're not going to have a kind of final decision on this thing for a long time. Even if we have a decision, at the Georgia level, it's only going to be sort of binding in that district, right? Even if we get to the 11th Circuit, it'll only be binding in that circuit. We could have a circuit split in California. So things will play out for a long time on this thing. I can guarantee you it will get appealed. So what we learn in the Georgia State case will be fascinating. I really can't wait to read that decision. But it is not the kind of, and now we know the answer. Even when that decision comes out, we still will have plenty of space to operate. And we hope that the code will be a space to either say, yay, right, the judge got it right, she's coherent with the library community, or boo, she clearly doesn't know what's happening out there in the library world right now. And perhaps at the next stage, we can use the code to help bolster that. And I know that we've actually put the code in front of the judge at this late stage. I don't know what she'll do with it. But.
Okay, thank you very much. Thank you all. Let's take a break, and if you need something else to think about, I'm going to put a little fair use puzzler up here on the on the board. But otherwise, it is just a couple minutes after the hour, 15 minutes, and we'll begin anew. Thank you.